and gentlemen, we couldn't start at 7 for obvious reasons. The reports were not ready. They are now ready, and I believe the parties have looked at them. Can we now have submissions on those reports as fast as we can? We want to start with Mr. who is doing it for the petitioner.
I'm grateful, my lords and my ladies. My ladies and my lords, as we have said, these reports that have come out prove beyond a reasonable doubt that these elections were shambolic. Indeed, if there is anybody that would have the audacity to defend this election from the reports that we've received, I think it would be a great disaster to the Constitution of Kenya and to the people who are sovereign. My lords, because of the limited time, I'll begin with a report coming out of the scrutiny of report as filed by the registrar. That was the group that was working at Milimani Law Courts. My lords, if you look from page 8 of the report, first of all, on page 7, the numbers of the forms that were made available are found in paragraph 13, the number of form 34C, 34B, and others which were downloaded, and form 34A. Paragraph 15, which I don't want to repeat, is again an inventory of all manner of transgressions that were committed in terms of the copies of the documents that were examined under the guidance of the registrar. But the story itself begins on page 9, in relation to form 34C, paragraph 23. The petitioners noted that there were no security features of watermark, and serialization were noted, and the form looked like a photocopy. This is the form that the chairman himself signs after the collation of the form 34Bs. So even the form that was before the chairman that has been produced does not bear those security features, leave alone the ones he was not handling directly. But now when we come to form 34Bs, my lord, is a very, very sad story. If you go to a bank, if you have a bad check, even if it is your account, you will not access your money. But my lords, now we are faced in a situation where we are being told from this report that more than 56 forms did not have watermark as a security feature. 5 forms were not signed by the returning officers. And forms that were stamped by the returning officer that have not been that were only stamped by the returning officer are 2. My lords, we are dealing with 291 forms. Forms without serial numbers, 31. We are dealing with 290 forms plus the diaspora, 291. These figures are critical. Forms not signed by the agents, 32. My lords, forms that did not have the handover section were not filled, 189. My lords, this is the form that is taken from the returning officer to that national tallying center. It's not from the polling station to the constituency tallying center. This is to the national tallying center. 189 did not have handover notes. They have not been filled. And there is another 103 of them that they had no handover section that they had been received. And my lord, it goes on and on. But the most, my lords, I will not stop there. I can barely talk because I can't believe what I'm seeing. I can't believe what I'm seeing. My lords, when it comes to the scrutiny done on your lordship's orders, and I will begin with the very serious ones. My lords, the first question is the question of compliance. As a whole, there has been no compliance with your lordship's orders. There's been part compliance. And in the crucial areas where there should have been compliance, there's no compliance. And my lords, what is contained in the database of the IEBC is the mirror of what took place during the elections. And not just on polling day, before and after the polling, all this should have been captured in the database of the IEBC. My lords, you'd see in paragraph 3.2, which deals with order B, about the firewalls. My lord, the court-appointed experts say that the first respondent was supposed to provide configuration of internal firewalls as the request is genuine. This is our own independent expert saying, and does not affect the vulnerability of the system. And they conclude by saying the internal firewall configuration was not delivered as ordered by the court. My lords, that's serious. My lords, in regards to certified copies of certificates of penetration tests conducted by the IEBC on the election technology system prior to the election, my lord, again, this one was not submitted at all. And this is important to know whether this system had integrity. My lords, again, when it comes to the documents relating to certified copies of certificates by professionals prepared to Regulation 10, again, of the same regulation, again, this was not provided. This is even more important, Order 1, found in paragraph 3.9. Specific GPR location of each KIMS kit used during the presidential election for the period between 5th of August 2017 to 11th of August. They said they provided the GPS locations for the polling stations, but not for the kits, which means that if those were provided, then they would have known whether these kits were used or not, and from where they were used. My lords, when it came to, I'm just dealing with the more important ones. When it comes to the read-only access, where your lordship said you can have access, but is limited to read-only access. My lord, this again was not provided. They say there was a live access, which there was an attempt to make around 3. This is 350, but without the ability to access the logs or even view them. Therefore, according to them, your own experts, your lordships, this was not granted. My lords, again, when it comes to log-in trails of users and equipments into the KIMS database management, this was a crucial one. Again, this was not granted. My lord, again, there was a request or an order for login trails for users and equipments into the KIMS database management systems. Again, my lord, that request was also not granted. It was an order, actually, it was not a request. And finally, my lord, there was required to be given information on soft copy of this request, and again, this was not provided. The general conclusion then is that the first respondent only agreed to provide read-only live access to the servers at about 11 a.m. today, but partial read-only access was provided about 3:15, but with no capability of copying. But from what you'll see from our reports, from what we have gleaned from what was granted, my Lord, it will be established that even the account of the chairman was being used for deletion of information that was in the database. That is what our experts have gleaned from this examination, from what they were given. They have also gleaned from what was available that there was unauthorized access by, in some cases, individuals who have been identified from what has been provided. My Lord, since I have only 20 seconds, from this, my Lords, there is no other alternative.
You need another few minutes?
Yes, my Lords, if I can be given.
Yes?
Yes.
Another 5 minutes?
Yes, my Lord. My Lords, what I would want to say in conclusion in these 5 minutes is that from the forms themselves, 34A, 34B, even the reports in relation to Form 34A, there was a random sampling of those forms. And again, even in respect of 34As, the ones that were made available, they had a lot of problems. And the counties and the constituencies have been mentioned in the report, on the report that was carried out at Milimani. In respect of the Form 34Bs, in totality, if you look at the numbers of votes that it affects, in more than 90 constituencies, where what's required under the law was either not done, or in terms of security features, you'd find that security features in those forms were found not to be in those forms. So the logical conclusion is that, my Lord, you cannot ignore the report in regard to the forms, and the forms are statutory forms. They are there to serve a purpose. And my Lord, when you look at the report, and in fact, if at random you could be calling for some of those forms, you'd find that indeed we are justified in terms of the complaints that we're making. And my Lord, from our own report, which you have filed in court, we have made also a report in reaction to this exercise. And there is no difference between what we have found out from what the registrar found out with the group of experts that he had. Just on the question of Form 34As and 34Bs. The conclusion of our report is that these forms that were irregularly that were irregular either on account of not being signed or not bearing security features, and for many other reasons which are stated in the report, affected nearly 5 million votes, and we have included that in our report. So it is not just a question of numbers. Now, my lords, the registrar must be commended. If you look at the copies of the report of the registrar, which was signed, and she made it available to us, she was going through file by file, constituency by constituency, and making remarks. There's the report that has been filed, but there's an additional working sheet that she had.
Yes, Honorable Muite.
Yes. My Lord, what my learned friend is referring to now are new documents that have just been filed by the petitioner. These two documents. This is the one he's referring to. Our understanding was that it's only the reports, the two reports from your registrar that should be being considered now. They are reports to the court because it is the court that directed the registrar to do so. And the court very kindly said the court will accord a few minutes to each of the parties to comment on the reports by the registrar. I think it's quite irregular to now file these bulky documents. They've just been handed over to us. We've not even had time to look at them. The confines of the directions are for parties to comment on the reports by the registrar. And I ask that this should not be permitted, this should be disregarded, this should be withdrawn, and my learned friend should be confined to commenting on the reports by the registrar.
Could I? My two learned seniors sometimes tend to overlook me. May it please you, my lords, I take an objection to a new document which has been filed. I've only seen one, so it would appear from Senior Counsel Muite there are two. The first one, my lords, is titled Petitioner's Report on Forms 34C, Bs and 34Bs, Examination Exercise. This is a new document. It seeks to introduce new evidence, introduce new allegations, and will have no opportunity to rebut them. My lords, it's the most irregular filing that I've ever come across, a filing being done post the conclusion of the case. I wasn't even served with the second document. I don't even know what it is. But the one that somebody casually put on my lap as he was walking is this one. This other one, I don't even know what it is. Be it as in may, my lords, I request the same fate to fall this, which is even a third one. It's becoming like a magician's box. I think I've dealt with them. There's a third one, my lords, which is Petitioner's Report from ICT Access /Audit Report. So there are three. I hope there won't be a fourth one. My lords, your order was quite clear. You are to give us 10 minutes to comment on the report from the two parallel processes. You didn't give us an opportunity to file or a cross-filing to be made. It will be most irregular if petitioner is allowed that latitude and we are denied an opportunity to be heard in respect to now 3 documents.
Mr. Ngatia, Mr. Ngatia,
yes, my lord.
When I allowed Mr. Orengo an extra few minutes, I know what I was doing. I was going to allow you the extra 5 minutes because I realized he had not finished.
Yes.
And I was going to allow all of you. Yes. The time I was going to give to Mr. Orengo, I was going to give to the 3 of you.
No,
but anyway, we have got your point.
Yes.
Yeah, we have got your point.
The time I have no difficulty.
Yes.
I may not even want to rival him with 15 minutes.
Yes.
I may still take my 10 minutes. I have no difficulty with the time. It's the new documents being filed.
Very well, very well.
My objection is to the 3 documents.
Now, let me ask this. Did each party file their own report apart from the one of the registrar?
No. I have not filed any report because that would be contra the order you issued. You always said we read it, come, submit on it for 10 minutes. So I have filed not a single paper.
Yes. Mr. Orengo? Mr. Orengo? Yes. We did not give parties liberty to file their own reports. The reports that were to be filed were by the registrar, who was there with you throughout. That is at Milimani. At is it the IBC headquarters? The report was going to be filed by the court-appointed experts. And those are the reports we have. So in that case, please take back your reports.
Yeah, my lord, I'll take it back, but note that if we are afraid from a working sheet by a duly appointed court official, so be it, but I will draw it.
No. We have only 2 reports.
Yes, yes.
As per our court order.
I don't want to complicate the situation, my lord. I'll withdraw it.
Yes.
I will withdraw it.
So withdraw your reports. The only 2 reports we have are these.
I will withdraw it.
This is from the court-appointed experts.
Yes.
This is from the registrar.
Yes.
So the others, please take them back.
Yes.
Yes.
Yeah. And I'm taking it back in the knowledge that it does not add anything, because in the report that has been filed in court is very comprehensive.
Yes, the ones we are relying on.
Yes, those 2
reports. The ones we are relying on are these.
Yes.
These 2.
Yes.
Yes. So who is this? The clerk, give back Mr. Rengo the reports he has given you. The only report you remain with are these 2.
Understood.
Very well.
My lord, I just want to say that somebody was talking about smoking guns. The 2 reports that the court has accepted, which are the ones officially sanctioned by the court, are 2 smoking guns. I was adding 2 more smoking guns, but according to your direction, I've pulled them out. But I think the 2 smoking guns are as good as even 1 smoking gun.
Yes, because you see, if each party decides to do what they want,
yes,
we can't have order. We cannot have order in this.
This you know, my lord, time was running out.
Yes.
We thought we may not even have the 10 minutes, so we are just being diligent.
Okay.
And just repeating what the registrar has said. Nothing additional. So, my lord, I'll pull it out, but conclude by saying that the other thing that I will request the court, that now we have been through this process of scrutiny, that, my lords, you'd ask for some of these forms which are now properly before the court, including the Form 34Bs. And, my lord, for you to examine those forms. And you'll find that some of those forms, or a big number of those forms, were not the standardized forms. They were not the forms that were prepared in accordance with the contract between the first and second respondent with the printers in Dubai. So that is a matter that is available to the court, is evidence which is available to the court, and our case has been proven that forgery, alteration of documents, trickery, and deception has been used in various ways, including the manner in which the server was used. And one can even question why that server is there in France and not here, to the extent that when France is asleep, we can't wake up. And, my lord, it is a sorry state of affairs, and these reports fully support our position that your lordships, and we pray, you should declare the election of the 3rd respondent, Uhuru Kenyatta, as invalid and not in accordance with the Constitution. Thank you.
Thank you. Yes, Mr. Mwite.
My lords, may I start on behalf of the first and second respondents?
You have also 15 minutes.
Thank you.
Yes.
May I start by paying compliments to the registrar of this honorable court, who at very short notice, severe time constraints, has been able, working with the IT experts appointed by this court, to produce 2 reports, which should be read and seen by your lordships in the context of the limited time. Satisfactory reports. reports that say the opposite of what the Honorable Orengo is suggesting they say. Although you also have limited time to go through these reports, but I urge you that you go through them, and where it is necessary, you compare the information here with the forms 34As which have been filed with the court, including forms 34B. My Lord, you will see from this first report, the blue one, that the registrar is complaining. She convened a meeting of the parties at 4 p.m. on the very day that she was told to commence this work. The petitioners did not turn up until 6:30. It's all captured in her report. You will see at page 10 the registrar saying, however, as the process went on, they introduced a new checklist. That's the petitioner, which is the modus operandi. Lord, let me make a few points here with regard to this report. One, at the time that the returning officer for the presidential elections announced the results, he had received all the scanned copies 34B. Let me repeat here that Form 34B for each constituency is the aggregate of Form 34As, copies of which you have here. When you are being asked to hold that the elections were not conducted in accordance with the law, you can only do that by looking at what the law requires with regard to Forms 34Bs and 34As. But when you look at the regulation 79 2A with regard to Forms 34A and regulation 83A with regard to Form 34B, you will find that the requirement is for those forms to be signed. And actually the format of the prescribed form, you will see it in the schedule to the regulations. So there is no requirement in the regulations about any security features. So you cannot be asked to disregard the forms because of security features. The regulations are clear as to what should be in the forms. And my Lord, if you turn to page Scrutiny of Forms 34Bs, it's not paginated, but it's schedule 7 in this blue form. With regard to the constituencies in respect of which the forms are said not to have been signed by the returning officers. 5 of them, 1, 2, 3, 4, 5. 5 of them. If you look at the column serial number, the form had a serial number. If you look at the next column, watermark, the forms had watermarks. Where it is, the next column is returning officer signed, that is the ones that are not signed. But the next column, agent, you will find they were signed by the agents. Handing over, we've already gone through it because that was under the old regime. Those are the only 5 forms which were not signed by the returning officer. They had the security features, they had the serial numbers, and you'll be able to see the number of voters in those particular polling stations. In fact, when you compare, you will see that the majority of them actually voted for the petition.
Excuse me, Mr. Muite.
Yes.
With regard to what you said about regulations
79
and 83,
Yeah.
that there were no security features required on these forms?
It is not a requirement of the law.
It is not a requirement of the law.
No.
But did these forms have security features?
Yes.
So meaning, if they had, they all should have.
Abundance of caution. The commission, out of abundance of caution,
Yes.
are the ones who designed the security features.
Okay.
Yes. And my Lord, we have explanations. It's just that there wasn't enough time. Because when you scan a copy, you can actually lose some of the security features. But what I'm saying
Mr. Muite, before
is
you
that the
move,
forms
Mr. Muite,
34, yes,
before you move,
yes, my Lord.
how do you explain Nyali in that form? And the serial number, or lack of it?
Yes, there is no serial number, but that's admitted.
What does that mean?
If I had time, I would take instructions. But if you go to the next column, my Lord,
Yes.
it says it is signed by two agents, ODM and Jubilee. So that the next question, my Lord, why were the agents of ODM and Jubilee signing the form for Nyali? So they are signed. Is it reasonable to expect a party who has signed a form to come here and disown the form? Look, the simple point submission I'm making here is that the forms 34B were in possession of the National Returning Officer for the presidential vote, and he was perfectly right in declaring the third respondent duly elected. My Lords, with regard to the forms about access, again, when you read this report on IT, on access to the system, you will find that in terms of paragraph 72 of your ruling, we availed all the orders of this code, the items that we are asked to avail. You see that we availed them. We even gave a soft copy of the logs, which the petitioner did not want to take. And my Lord, we set up the link, passwords we are given. My Lord, you will see from this report that the company that we were relying on as a commission for this system is NTT in America. The servers were in Europe, but the company NTT is in America. And you know the time difference is 8 hours. My Lord, can I have some peaceful environment to make my submissions?
You said who are in you?
NTT, America.
Yeah.
They are the ones who are contracted by Shaft. No, Saffron. And my Lord, the point is this. After giving the link, giving the access, because of the super security features in this system, it took time to access. In simple language, it's like mtego wa panya in a city park, as it used to be. You know, when you go to the door, you can't get to the center until you go around all the parts. It takes time to get round the firewalls and access. And that was a challenge. And that was being set up by our service providers. So it took time, not us refusing. And the fact that it took such a long time is evidence of the security features in the system, which then demolishes the suggestion that anybody would have hacked. And you will have the opportunity to study this report as to whether indeed your experts themselves saw any evidence of hacking. So you cannot be asked, my lords, to nullify a presidential election on the basis of allegations, on the basis of suspicions, my lord. No one is challenging the numbers, the votes. Those are not being challenged, my lord. What we are being told is this did not have a watermark, this did not, but you have not been told even now that the figures in any of Form 34B, that any of the figures in Forms 34A were wrong or cooked. You have them here. And even with the constraints of time, look, your staff, your registrar can go through them, my lord. And once you are satisfied about the figures, the sovereign will of the people of Kenya was captured in Forms 34A, Forms 34B, and Form 34C, my lord, was completed. That was the one that was completed most transparently, because everybody was able to follow the chairman of the commission signing that form in the presence of all the media. There's absolutely nothing wrong, no evidence. And my lord, the fact that this court, as the registrar, to do that limited scrutiny in terms of time does not shift the burden of proof. When you retire to consider your judgment, you will ask yourself, I submit, whether the petitioners have presented this court with any cogent evidence that these elections were rigged. By who, when, and how have you been presented with that evidence? All they've been talking about is this technicality and that technicality. My lords, the results announced captured and represent the will of the Kenyan people. My lord, it is a fact that the judgment of the Court of Appeal, which was given on the eve of the elections, presented certain challenges. For example, my lord, the Chief Justice kept asking, those figures that we were seeing on the screen, what were they? My lord, it's necessary to distinguish between the public portal and the screen. They are different, they are not the same. And therefore, the raw information in terms of how the people have voted is what was being beamed on the screen. And my lord, following your lordship's judgment, given that this judgment of the Court of Appeal came on the eve of the elections, the commission will take steps to improve on how communication of the result should be, to harmonize the public portal and this screen, perhaps to wait for the form to be received instead of the results data being keyed in on these KIMS and being transmitted and then being relayed immediately. Perhaps wait until Form 34 is completed so that as you feed it into the public portal, which is not accessible by a majority of Kenyans, you also screen it so it can be picked up by the media so that the Kenyan people can be able to follow because they are entitled to follow. The Commission was trying to comply with the Court of Appeal order that removed the issue of provisional reports and at the same time respect the constitutional right of the Kenyan people to have information as quickly as possible. This is a petition that stands for dismissal. And as I sit down, this is one of the petitions that we ask you dismiss with the costs.
Thank you. Thank you very much, Mr. Mwite.
Thank you, my Lord.
Yes, Mr. Ngate.
Thank you, my Lord. My Lords, within the time we've had, we would wish to discuss or submit and limit our submissions to the first document, annexure number 4, the scrutiny of Forms 34Bs. My Lords, I start off with the constituency Kisauni is indicated as if the returning officer did not sign, but it was signed by the agents. Our comment on that is this: please verify with the 34B that was submitted to the court, because we have looked at a copy and the copy is signed by the returning officer. There could be errors in this document, but it's important the court to verify. And as the court is verifying, allow me to say this. The petitioner had 56,000 votes as compared to the third respondent who had 17,000 votes. And I don't think I need to say anything more. That is a constituency where it is the petitioner who had more votes than the third respondent. The next is Nyali. In Nyali, again, it's indicated returning officer did not sign, but 2 agents, one of ODM and Jubilee, have signed. Once again, my lords, I request the court, before making any decision on it, to verify with the 34B that was submitted to the court.
Where are you reading?
Scrutiny of Form 34B, Schedule 4. Schedule 4.
Schedule 4, okay.
I am now at the middle of the page, Mombasa, Nyali. And as regards Nyali, my lords, the person who garnered more votes is the petitioner at 41,000 against the third respondent with 19,000. Once again, I do not need to amplify any further. If that vote was to be discounted, to whose prejudice that would be. And finally, Likoni, it would appear all these problems are in our coastal town. In Likoni is again indicated as if returning officer did not sign, but 8 agents signed. In Likoni, my lords, petitioner got 38,000 votes as contrasted to the third respondent who managed 10,000 votes. Again, the consequence should be as clear as day follows night. My lords, apart from that, most other 34Bs have been signed by returning officers and by the agents. a great majority of 291-34Bs have all been signed by returning officers and by the agents. What does that demonstrate? It demonstrates two things. First and foremost, my lords, the fallacy that many 34As were missing is untrue. All the 34As were used to generate 34Bs. And we know that because from the polling station, the 34As would go to the constituency for collation, verification, and compilation of 34B. Next point, my lords, we left this court with a very sensational submission that IBC took some time to go and now correct all these documents. Correct the documents so that they are all very well collected and well presented. That cannot be true because you see there are still some errors in the documents. So that sensational comment goes through the window. Third point, my lords, there is no allegation that the votes in 34A differ with the votes in 34B. There is no numerical difference. There are some instances, my lords, and I think we all need to see those instances, where due to certain difficulties, for example, Isiolo South, the 34B is not signed because the printer broke down. RO had to travel 150 kilometers to prepare that document. I am reading what the registrar has captured. The comment, while that form was not filled by the agents, is because the printer broke down, and it's all indicated there. My lords, in our submission, this fortifies what we have said all along. Fortifies what we have said all along, that this was a very credible election within the parameters of conducting an election. My lords, I go to the IT, and before I go to the IT, my lords, the final comment on the scrutiny, there is no allegation that the vote announced at the polling station differs from the vote in 34A. So with all those, my lords, the only conclusion one can reach in my submission is that 34A as well as the 34B correctly reflects the votes cast in favor of all the presidential candidates. And I repeat here, my lords, that the unreformed 34Bs that on the face of this appear to have a problem are actually where it is our political opponent who had more votes than the third respondent. So we would not wish those to be taken away because that to us is purely a clerical error. If the returning officer did not sign, it was a clerical error. But we tend to think that actually the returning officer must have signed for the agents to have signed. And we see in one of them, 8 agents have signed. My lords, I go to the IT. The IT report has a few errors and we request the registrar, in the fullness of time, to compare this report with the handwritten notes that were done by our representative. Because in certain instances, what is here does not marry with what our representatives were requested to sign for. And they signed for each and every part of this report. I start off, my lords, at page 7. Page 7, letter H. And then towards the bottom of that page is court-appointed IT experts. Documents submitted were not certified. My lords, the note our representative made is that the certificates were provided. Certificates were provided. On the next page, my lords, right on top, against the expert who was working on behalf of the registrar, right on top, again, there is the comment, documents submitted were not certified. That is incorrect because the certificates were provided. And as a matter of fact, the annexures to this document are the report or the document that was signed by our experts, and they actually said on that, we have seen the certificates have been provided. Maybe because of the hurry of doing this, there was no time to edit this report. My lords, at page 10, we start having a bigger problem. At the middle of the page, 3.14, our expert has instructed me that where it is indicated against the third respondent that there was no comment, that is incorrect. The correct position is that our representative was satisfied that the soft copy fulfilled the order. So as against the no comment, the correct position is that our representative was satisfied that a soft copy fulfilled the order. And equally, at the bottom of that page, the same position holds true, that our representative has signed against the schedule that the court, the registrar provided, that we were satisfied with the order. I turn to page 12. Page 12, about the scanned and transmitted copies of Forms 34A and 34B. And the comment I have from our technical team is that...
My Lord, I was not allowed to put a document. Mr. Ngatia is now giving evidence. Mr. Ngatia, my learned friend, is now giving evidence of what his experts have told him, and is not part of the report. I don't think he can be allowed to do that.
Perhaps let me repeat.
He can comment on it, but he cannot rebut the report on the basis of what he has been told, because that is not his duty as counsel, to give evidence.
Let me repeat, maybe I wasn't clear to my learned senior. I say that there are annexures to this report. The annexure is a document that our representative has written handwritten notes.
It's not here, my lord. We have a report which you have been given by the court. And that annexure was a strange document, which we don't have.
No,
we don't have it.
Maybe the judge could indicate.
Maybe there's something happening somewhere.
Too suspicious.
Finish off, Mr. Ngatia.
Yes. I'll finish off, my lords, because I was coming to the conclusion at page 13, and our comment on the conclusion is that there are three comments we'll make on that conclusion, because in one respect we differ with it. My lords, the first respondent, that is IEBC, notified us, as well as the petitioner, that the read-only access would be made available today at 5 p.m. Petitioner requested for admin rights at that meeting. That to us was beyond the order that was made by this court. Admin rights, my lord, is not something that parties were given. We were given read-only access. We cannot expand the terms of the order because it becomes now suitable for one party to expand the terms of the order. The next one, my lords, is our disagreement with the sentence reading partial access became available after the meeting had been called. First respondent had indicated if granted more time. First respondent did not request for time. On the contrary, the person who requested for more time is the petitioner. My lords, apart from that, we have no difficulties with the other contents of this report. It is a fair report given the time and the urgency that the matter had to be attended to. And once again, my lords, it is our submission that this report fortifies what we have said all along, that indeed this was a fair election where integrity of the vote was protected to the last, as far as humanly possible. I conclude. The totality of this exercise, my lords, would establish beyond any argument that contrary to what has been a recurring theme about missing Forms 34A, nothing like that ever happened. All the 34As have been accounted for to the last one, and they were accounted for at the right time at the constituency level. Once they were accounted for, they were captured in 34B, and the 34B is the forms that were used at the National Tallying Center for compilation of 34C. In those circumstances, my lords, there would be no ground in our submission for any challenge to the result that was announced. Thank you very much, my lords.
Thank you very much, ladies and gentlemen. I want to take this opportunity on behalf of my colleagues to thank you for the cooperation you have shown throughout. I also want to thank you for the courtesy that you have had for each other and even for the court. We didn't have any acrimonious exchanges, and that is the way it should be. I want to thank you for all that. That brings us to the end of the hearing. You people are going to sleep now. We don't have that luxury ourselves. We will deliver judgment on Friday. I can't tell you the exact time, but notice you will be notified by the registrar. Once again, we want to thank you very much. I hope you all understand that because of the size of the court, we were not able to allow in as many members as the court proceedings are public, and we would have liked to have as many people come in as possible. But because of the size, that was not possible, and that explains the restriction that was put there for those who were able to come. I want to also thank The judges, our foreign judges, I can see the former Chief Justice of Zambia is still with us. Thank you very much for your patience and staying with us until the very end. Thank you.
My Lord, may I, on behalf of the bar, ask that our appreciation on the part of the court for the long hours that the court has sat almost on a daily basis. We appreciate the accommodation to counsel to articulate their respective cases, and for the courtesy that the bench has shown. May I also, again, on behalf of my colleagues, take this opportunity to wish the quickest possible recovery of one of the judges of this court. Thank you.
My Lords, I also would want to join my colleague in thanking your Lordships and my ladies, particularly for the long hours, as my senior, Mr. Paul Mwita, has said, and the conditions in which we have operated in the courtroom. I think it has been a very enabling environment. And beyond that, for those who know the court very well, I've been able to find even food and coffee occasionally, and that has been an added advantage and privilege. Thank you very much.
Thank you.